Hi, my name is Nick Dahm, the president of the Emory Tower Tenant Association. I decided to make a quick video to try to help explain several of the challenges we are having. I've heard issues about leaks during rain, a rat problem that's possibly happening in several tenant locations, and I wanted to explain our situation legally and what other options we have related to the implied warranty of habitability in Georgia. So for starters, what is an implied warranty of habitability? Essentially, it's a legal doctrine created by case law. In a lease, all leases imply a warranty that the property will be fit for its intended use, and of course, habitable in a habitable condition. The issue, as I see it, is what is the definition of habitability? Courts commonly look at this on a case by case basis. They look at the nature of the problem, the effect caused by the problem, the duration of the problem, age of the building and its location, how much rent we pay, that makes a difference. And then did any of these defects potentially get waived with our lease? So some considerations for us is this is all very hard to prove legally because a simple building code violation is not necessarily a defined term for habitability. And it really boils down to if a reasonable person would consider it bad or uninhabitable. And we must meet the burden of unsafe or unsanitary to be successful in a court of law. Aesthetics don't seem to meet the standard. So some possible remedies. Many times in Georgia, these matters are contractual by nature. So our leases are key. I'm going to ask everyone to look at them. And the equation needed to be used is the common value, which is essentially a rent minus what the rent would be worth with the defect equals our damages. So that's what we're working with from a liability perspective or damages. Of course, any injuries or damage to property caused by those effects also count. As I see it, we have four options. The first is work with the landlord as a group to try to get it repaired. We could, two, repair and charge the landlord back. There's a couple of ways to do that. Some people have even considered and are talking about stopping paying rent or rent abatement, but we would need a legal team, I think, for that, at least in my perspective. And then, of course, terminate the lease. So in conclusion, because tenants rarely get punitive damages for emotional distress or attorney fees, we need to be cautious. I want everyone to get their lease, review it, and I want to categorize and catalog the provable defects and consider the options 1 to 4 listed above. I recommend choice one, starting with trying to work with the landlord, and then of course making a case for number two, the repair and charge the landlord. I do not recommend option three, stopping paying rent without more documentation. And option four is always on the table. It's break the lease. So in closing, I've already scheduled appointments with the local fire department, the fire marshal's office for fire and life safety reasons, the local building department, the local health department. I also suggest we pool our money, get a roofing contractor, a rodent contractor, a siding contractor, and a professional building inspector. We review what they give us, and then I think we meet and discuss the next best option. Hope everybody's having a great season, and we will talk at our next meeting.